Whenever you have a major Supreme Court decision like we just had in Cargill versus Garland, where the Supreme Court, in a 6-3 decision by Justice Thomas, concluded that the ATF's ban on bump stocks through administrative action was unconstitutional and illegal. We have to look at all the other aspects of the opinion, because remember, whenever we talk about the Supreme Court, it's not just who wins the case that's important. In many respects, what's far more important to you and to me is how someone wins the case, the methodology that's followed. Today, I want to talk about the strategy of the anti-gun left in this decision, specifically the 3 justices that dissented and were perfectly fine with the ATF just making up a definition of machine gun to encompass bump stocks and allowing them, the deep state, to do anything they want. I'm happy to report, though, that 6 justices followed the rule of law and rejected the arguments made in the dissent by Justice Sotomayor, signed on to by Justice Kagan and Justice Brown Jackson. We're going to look at what the dissent has to say, and we're going to break down the fallacies they articulate, so you are the smartest person in the room. As always, stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teach Americans About the Right to Bear Arms. Remember, we learn on this channel from all around the world information that you need to know. And learning the mistakes of the Israelis by failing to encourage their citizens to be privately armed, all in deference to having more and more government security, was a terrible mistake that our founding fathers here in the United States did not want made. That's why we had a Second Amendment. And Israel doesn't have a Second Amendment or a right to keep and bear arms. It's a privilege and not a right. And the consequence of that, as I articulate in extreme detail in my book, Israel Disarmed, is 1,200 people murdered in a day and hundreds of people taken hostage because the Israeli citizens were not adequately protected. Nor could they be, because we know when seconds count, government is usually minutes away. And in the case of Israel, when seconds counted, the government was in many instances days away, unfortunately. Break down that story, break down that information. A lot of historical information there that you can use discussing the Second Amendment. Check out Israel Disarmed, my new Second Amendment related book. All right, folks, so big win, Cargill versus Garland. We've talked about this. The bump stock ban was struck down as unconstitutional. This is a huge win all the way around. It also, to me, is a vindication of President Trump, again, with his 3 Supreme Court picks, Neil Gorsuch, Amy Coney Barrett, and Brett Kavanaugh, 6-3, all of them in the majority saying this was unconstitutional by the ATF. And not only did we knock out the bump stock ban, we also thwarted Congress, who undeniably was going to screw up the definition of machine gun if they tried to expand the definition of machine gun to encompass bump stocks, which would have been absolutely catastrophic to the Second Amendment movement for a whole host of reasons we'll cover in a separate video. Very important to understand that strategic decision by Donald Trump and the NRA to basically sign off, if you will, on doing a bump stock ban through executive order. I didn't like it. I was not happy about it, but I understood the strategy. Sometimes one has to lose battles to win the war. That is how the real world works. You never want to lose any battle, but sometimes you don't have a choice if you want to win the ultimate war. And the war we're trying to win here is to preserve and restore our rights in all respects, including but not limited to the right to keep and bear arms, preserved and codified by the Second Amendment. Now, with that said, let's talk about what happened in this Cargill versus Garland case. Again, I want to look during this video at the anti-gun arguments advanced by the 3 dissenting justices. That's right, there were 3 justices, Justice Sotomayor, Justice Kagan, Justice Brown Jackson, that all said that this bump stock ban by the ATF was perfectly constitutional, was perfectly fine, because adding a bump stock to an ordinary semi-automatic rifle made it a machine gun, and therefore you could ban the bump stock. They had no problem doing that, notwithstanding the fact that statutory language was not what it says. And also ATF for many, many years disagreed in all respects. And then they just shifted course out of political convenience, as opposed to going to Congress to trying to pass a law, which of course would have been bad for the Second Amendment movement. So I'm glad they didn't do that. But that was actually, technically speaking, what should have happened as a matter of separation of powers. Not allow the ATF to make stuff up out of thin air, but to go to Congress and pass a law. That is how the old school song, right? You know, I'm a bill on Capitol Hill kind of stuff. That's how it's supposed to work. Congress passes the laws. The executive enforces the laws, and the courts interpret the laws. But of course, here you have the president and the executive branch making laws, and the Supreme Court justices in Cargill versus Garland says that is a no-go. So what exactly does the dissent say here? Well, of course, the first thing the dissent does is exactly what every anti-gunner does in America. They immediately start to appeal to emotion, which is a logical fallacy for anybody that takes a Logic 101. So they immediately start talking about gun violence, shock or shot. So, for example, the dissent begins with a discussion of the Las Vegas shooting. So let's see what the liberals on the court have to say. They immediately start talking off about mass shootings because there's really the only argument that they have about gun control. Of course, mass shootings really just proves the point that government can't protect us. We have to protect ourselves, because if government could protect us from mass shootings, they would, but they never do for a whole host of reasons. And that was the case with Stephen Paddock in Las Vegas. So here's what the initial talk about gun violence by the dissent, as predicted, talk about dangerous people that do violent things because they're criminals, as opposed to how law-abiding citizens use guns. But we don't measure constitutional rights by virtue of how criminals can misbehave or abuse something. We talk about constitutional rights by how law-abiding Americans can enjoy them, and criminals will be criminals. You cannot change that with a law, or we just pass a law that says no murder, and that would solve the problem. But obviously it doesn't work. So here's what the dissent says in terms of their appeal to gun violence. On October 1st, 2017, a shooter opened fire from a hotel room overlooking an outdoor concert in Las Vegas, Nevada, in what would become the deadliest mass shooting in U.S. history. Within a matter of minutes, using several hundred rounds of ammunition, the shooter killed 58 people and wounded over 500. He did so by affixing bump stocks to commonly available semi-automatic rifles. These simple devices harness a rifle's recoil energy to slide the rifle back and forth and repeatedly bump the shooter's stationary trigger finger, creating rapid fire. All the shooter had to do was to pull the trigger and press the gun forward. The bump stock did the rest. Again, immediately appealing to gun violence as an argument, but that's not the argument for what the statute means. The second thing, of course, we've talked about this in the prior video, the phrase here that they use, commonly available semi-automatic rifles, is devastating to the anti-gun movement, because they're admitting here in a Supreme Court opinion by the anti-gunners, almost like an admission against interest if you're a trial lawyer, right? They actually are calling this commonly available semi-automatic rifles, which is almost a concession that these, and I think it is a concession, that these semi-automatic rifles are in common use by Americans for lawful purposes, which of course they are. They're ubiquitous. And here you have the most anti-gun liberals on the Supreme Court in a Supreme Court dissenting opinion making the case for the Second Amendment community. That's very good. Now, the next thing is, now I'm not a super duper expert on the Las Vegas shooting, but I can tell you, and maybe you'll correct me if I'm wrong in the comments below, I am not aware that it has been proven or established that the guns that the shooter, Stephen Paddock, had in Las Vegas that he actually used during the shooting were the same firearms that had the bump stocks attached. In other words, it's not clear, and maybe it's out there. I've not seen enough evidence to persuade me that there's no doubt that he actually used and shot firearms with the bump stocks attached. And I am not sure that the FBI data on this and the reports by the FBI on this are crystal clear. They seem to fudge over, at least the ones I've seen, and you'll tell me if I'm missing something. They seem to blend and conflate the guns he used to shoot people and other guns that were in the room that he didn't use, but they happened to be in the hotel room because apparently he had a lot of weapons. So I'm curious, has anybody actually seen the actual proof from the FBI that Stephen Paddock actually used bump stocks to commit the murders he committed, which of course was a terrible thing. But again, if he didn't actually use these bump stocks, well then why are we talking about bump stocks? But obviously this argument here by the anti-gunners is presupposing or presuming that these bump stock laden guns were actually used to commit the murders, when I'm not sure factually that has been established. But let's carry on. The next critical thing here is they basically have blown themselves up in that, remember, the definition of a machine gun is a firearm that shoots multiple times repeatedly, by a single function of the trigger. A single function of the trigger. The idea being you pull the trigger back and the gun will just repeatedly fire and fire and fire until you run out of ammunition or you let go of the trigger. The speed of fire is not relevant. The rapidity of fire is not relevant. Again, we've talked about this. You can have a machine gun that fires one round automatically every 3 minutes. That's a very slow rate of fire, but it's technically a machine gun because if it's set on automatic and there's no human intervention, that is an automatic weapon, even though it slowly fires. In contrast to someone that can pull the trigger really fast, that's rapid fire. But again, that's irrelevant to the definition of machine gun. The reason why I bring this up is if you look at the dissenting opinion, they basically are making the point of the Second Amendment community. This is what they write. Quote, all the shooter had to do, listen very carefully, all the shooter had to do was pull the trigger, hear what I just said, was pull the trigger and, not a single function of the trigger because you just added the word and. All the shooter had to do was pull the trigger and press the gun forward. Those are two manual actions, right? I'm holding the trigger, I'm pulling the gun forward. Is that a single function? No, hello. It's obviously at least two functions, the function of pulling the trigger and the function of pushing the gun forward, right? That is two actions, or two functions, not a single function. And the definition of machine gun is, it shoots repeatedly by virtue of a single function of the trigger, not multiple manual manipulations. And I think Justice Barrett, we have to give her credit. She literally during oral argument talked all about how she watched all the videos, presumably on YouTube, by the way. She watched all the videos that were recommended to her in all the briefs to study the technology. And she's the one that asked the hypothetical questions about, well, why is the bump stock even relevant? Can't I effectively do this with like a bump ban or something like that? Literally, this is what Amy Coney Barrett is discussing. I know a lot of you are upset with Amy Coney Barrett because of how she handles some of the emergency applications to the court. But I've always said, well, on these merit-based issues, when you get to the ultimate question presented, Amy Coney Barrett, Justice Barrett, I think is going to get it right every time. She certainly got it right here. So did Brett Kavanaugh, so did Neil Gorsuch, so did Chief Justice John Roberts. Again, there are certain areas at the margins I'd like to see them be more aggressive with and more aggressive at. But again, I think at the end of the day, they get to the right answers on these Second Amendment questions as a general rule every time on the merits. But again, if I were on the court, I might be a bit more aggressive in how I take cases, but ultimately when they decide it, as you can see here today, they get to the right outcome. And again, of course, the only thing these liberals care about is government power. They're much more interested in making government have powers over us. As we've talked about before, there is a difference between power versus authority. One can have power over someone, but that doesn't mean they have the lawful authority. So if Vladimir Putin, for example, illegally kidnaps somebody, he has power over that person, but that doesn't mean he has a lawful authority to do that. But here you have the anti-gun justices on the Supreme Court are trying to expand authority and power and give all this stuff to the federal government, to the ATF to do whatever they want. Here's what they write in their dissenting opinion. Today's decision to reject that ordinary understanding will have deadly consequences. The majority's artificially narrow definition hamstrings the government's efforts to keep machine guns from gunmen like the Las Vegas shooter. So again, it's these ongoing appeals to emotion. Now, I want to remind you of something because we covered this extensively after oral argument. How many of you remember what Justice Brown Jackson talked about during the oral argument in this case of Cargill? She's literally talking about, I'm going to remind you, 800 rounds a second. I kid you not. You remember this. I played you the tape. You actually got to hear it here on the Four Boxes Diner when she was saying it, right? Here's what she's saying. Don't forget that Justice Brown Jackson literally was saying this. She says that, quote, the function of this trigger is to cause this kind of damage 800 rounds a second or whatever. That's not me. That's not Oprah. That's not Kamala Harris. This is a Supreme Court. Now, that was not the only time she said it. She goes on in a different part of the oral argument, talks about 800 bullets. 800 bullets. You can achieve the same kinds of result in terms of the amounts of bullets that have been ejected. 800 bullets. So again, 800 rounds, 800 bullets. This is what Justice Brown Jackson's talking about. I'm curious as to what outside of like maybe a military plane or a helicopter, a Black Hawk helicopter or something. I'd like to see a magazine that holds 800 rounds because I've never seen one. I assume the military has lots of those, but that's not what we carry, or that's not what we have here as civilians. But nevertheless, set that issue aside. That's the sort of thing that we saw by the anti-gun left of the Supreme Court. But the good news is, at the end of the day, the U.S. Supreme Court stepped up, did the right thing, and these are some of the arguments we saw from the anti-gun dissenters. Just be aware of this. And the last point I want to make, and this is why I call this ductualism, not to be confused with textualism, not to be confused with originalism, not to be confused with judicial activism, but this is what I call ductualism, right? Ductualism. Now, what is ductualism? It means if it looks like a duck and quacks like a duck, it's a duck. Well, is that really true? Well, Justice Sotomayor, in her dissent, says exactly this. I kid you not. This is the sort of thing I would expect out of a high school senior writing about public policy. This is what Judge Sotomayor wrote in her actual dissenting opinion. When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump-stock equipped semi-automatic rifle fires automatically more than one shot without manually reloading by a single function of the trigger. Because I, like Congress, call that a machine gun, I respectively dissent. Well, there you have it, folks. If it looks like a duck and sounds like a duck, it's a duck. That is the kind of logic we're seeing here in the U.S. Supreme Court out of the dissenting liberals. I'm happy to report, though, that the majority of the court ignored that, and they analyzed the text of the statute and compared it with what ATF did. And remember, ATF originally said that bump stocks were not machine guns because that was clearly the right answer. They only did an about-face after getting public pressure involving the Vegas shooting. And of course, I think there was some strategic encouragement by the Trump administration to make sure that the Congress did not do something dumb, which, as you know, as we saw in 2022, if you allow the John Cornyn's of the world to write legislation involving guns, you're going to get stuff that's going to backfire big time on the Second Amendment. So the last thing we want is any of those kind of bozos touching any of our gun laws, because they will undeniably create opportunities for the anti-gunners to exploit in various ways. And we don't ever want them to touch any gun control laws, as we saw in 2022, where they only create opportunities for mischief and don't do anything for public safety, and certainly don't do anything to respect the Second Amendment's right to keep and bear arms. So there you have it, folks. Make sure you subscribe here. And I'm trying to get to 150,000 viewers, or I said 150,000 subscribers. Don't forget to follow me on X, and make sure you check out my book, Israel Disarmed. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.